Handler County, this is Tony Thompson. If you are a genealogist or a Georgia history researcher, you will know this guy by the books that he's written. He transcribed early inferior court records and early superior court records from the early 1800s for Tatnall. He wrote an exhaustive account of the Thompson and allied families, which is called Kinfolks Across the River. That's not all he's done, hang on. He graduated Long County High, then the UGA with a BS in social science education. He taught for 13 years at Metter Middle and Metter High Schools, where he coached girls basketball and cross country, and 3 times they gave him the Coach of the Year award. 5 books, I already named 3. So the other 2 are It's Not What You Know, The Battle to Control How You Feel About History, and The Lost Village of Ohoopee Sawmills. He's been married for 31 years to a lucky woman, Dina Bledsoe Thompson, and they have 2 girls. Tara is a freshman at Georgia Southern, and Haley, a junior at Pinewood. Tony is a Sunday school teacher at Excelsior Baptist Church, where he's very active, and we are so grateful to have him.
I didn't expect her to read all that, but I'm glad she did. I'm going to talk, I'm going to ramble a little bit today. My classroom, I was telling somebody coming in, it's a pleasure to talk to people after they've eaten and have a full stomach. Because as an 8th grade teacher, I have a remarkable talent for putting 8th grade students to sleep. So I hope that doesn't happen today. Or as those people who were listening earlier, when the people listening, I believe it was George Washington, wept all the way through the speaker. I hope that doesn't happen either. It's fortunate to have my girls with me here today. Speaking of that, after you eat, sometimes you have a full stomach and you've got all those nutrients in you. It reminded me when I was, some of you are probably old enough to remember Art Linkletter. You did say that I'm a girl, I apologize. I'm going to share one with them. Okay. I used to tell my girls to drink their milk at every meal because I said it had vitamins in there. And so one day I saw them just staring intently at the glass of milk. And I think it was Haley was looking at it, just really staring. I said, "Baby, what's the matter? What are you looking at?" She says, "I'm trying to see those vitamins." But anyway, it is a pleasure to be here today. Isn't this a marvelous event, y'all? Let's give Denise an This is just marvelous. We've been long seeking a venue and a place to talk about and be proud of our history. And this is just a remarkable beginning. I hope it just grows from here. But I'm excited to be here today. I'm going to try to ramble and keep I'm allotted about 30, 40 minutes. I'm going to try to cut it short so we have time for some questions. And I'll be real careful during that question period because somebody will ask me something I don't know. Just go ahead and tell you right now, I don't know everything about this, and I know just enough to be dangerous. I'm not an expert or an authority, but I love it. So what I don't know about it, I make up for my enthusiasm for it. So bear with me. Just to start, to preface, it was the spring of 1805. In a little tavern nestled among the sawmill community that sprang up along the banks of the Ohoopee River, the names of 94 men were read aloud in a makeshift courtroom. The names were those of the jurors chosen for the fall sessions of the 1805 inferior and superior courts in the newly formed Tatnall County. That scene was played out all over our country, our state at the time. Twice a year, the courts would meet, and the names of the people who were going to serve were called and read aloud in these tiny courtrooms. It may have been a church, it may have been a makeshift building, it may have been a house, it may have been an actual courthouse. But this scene was played out all over, and we're talking in this area. And I'm going to talk about the Wiregrass region, but I'm going to tie it back to Tatnall County because that's what I've focused on. Janice, if you could advance. The inferior court is the court that I'm closest to professionally, because as a probate judge, that was the court that we came from. The inferior court, later was called the court of ordinary, or even contemporaneously called the ordinary court, even in the early days. It was the inferior court. Has nothing to do with it being less important than the superior court. It was just a way of distinguishing the two courts, and the court of ordinary kind of comes from our common law tradition, our English tradition. The functions that were performed in the inferior court were tied to that English tradition. I'm going to zoom through this here and try to get through some of the meat of this and get to the end of my presentation, which has some primary sources that I really want to share with you. But just to give you some background, the 1789 Constitution stipulated that the justices' positions, the justices of the inferior court, would be filled with the first 5 justices named by the General Assembly for the peace of the county, any 3 of them to constitute a quorum. So in the early days, you didn't have 1 probate judge, you had 5, or inferior court justices, and when 3 of them would meet, you had a quorum, they could hold court. Today, I often long for that situation where I could have some friends on the probate court with me to help me, do some things. But also, this lens, you got to understand that this meant that the names given to the General Assembly were given by the local legislators of men who were considered, able-bodied, good-thinking men of good morals, good character, who could make these decisions. By 1812, those justices were elected. The idea of probate court, or inferior court as it were, actually predates the Constitution, because, and I don't want to get into the tail male head right passing a property, if you talk genealogy, people are probably familiar with that, but the idea of an inferior court, or the court of ordinary, predated the Constitution of Georgia, because you had to have a way to pass property from the deceased to the living, even before we had our Constitution. So it goes back a long way. Even today, I just got to say this, these local justices, these local inferior court judges, they were the face of the judicial system, even back in the day. I mean, even at the beginning of our state and our country, these local justices are what people saw. When they dealt with the judicial system, they were dealing with the inferior court for most of their dealings. And that's really true today. Most people who deal with our judicial system deal with their local probate court. So that's a long-standing tradition. Okay.
Oh, I have to point it. I'm sorry.
That's okay. I'm just referencing these from Tatnall County from the period 1805 to 1832. I heard the name Tippins mentioned earlier. I'm not going to read all these to you, but you can just see this is kind of a roll call of the men who served as inferior court justices from the period 1805 to 1832. The third name on there, James Thomas. Thomas Creek was named for him. My grandmother was Lannis Thompson. She is, we're related to James Thomas distantly. He had no children that I know of his own, but I think he was a great uncle, of some degree. But all of these men were highly regarded in their community and served for various terms as inferior court judges. Okay? I'm going to move now to talk a little bit more about, I'm going to leave the inferior court judges and now talk about the superior court judges. My fellow probate judges would be mad with me at this point for not spending more time on the inferior court, but I think for the purposes of our time today and to tie in with what we're talking about in the bigger scope of things, I want to focus more on the superior court judges. The superior court judges in Georgia in the early days, the Constitution provided for a superior court in each of the 11 counties to meet twice yearly in the spring and fall. And these roving court judges, circuit riding judges, were called the chief justices. I don't want to kill you with this, but understand this: the judicial system in Georgia during this period, before 1845, consisted of your local inferior court justices and these traveling chief justices. This was the highest level of court that you had under the Constitution until 1845. There was a third circuit added in 1797, and those circuits continued to grow until 1845. There was no court of appeals Until then, if you didn't like the way something was done in the Superior Court in your county, well, you just appealed it to the same court, okay? And you would get a new jury, and you might get a new justice, you might get a new judge. You might not. You might have the same judge who ruled against you the first time, but at least you'd have a new jury. A lot of reasons for this. If Mark were here, I'm sure he could help us a little bit on the background on this, but I think a lot of it had to do with people didn't like the idea of having a jury in front of people, go to an appeals court that was far away and meet with people that they didn't know. They were kind of comfortable, keeping it local, but that was the way it was. You didn't have an appeal. Now, and even, you go back to look at the inferior court just a second, just to say, if you didn't like the way something was done, certain things, inferior court was typically more civil matters. If you didn't like what was done in the inferior court, you could appeal it to the superior court. So you had an appeals level there. And then if you didn't like the way the superior court dealt with it, you could appeal one more time to the superior court, and that was the end of the road. But that's just the level of appeals. Saying this about these justices and the type of work that they had to do. Even in 1845, when there were 11 justices, they traveled over 1,000 miles each yearly. And mostly that was on horseback at their own expense. So think about that. They're traveling all over the state of Georgia, 1,000 miles, mostly horseback, at their own expense. Janice? The districts, there were in the beginning, there were 3 districts, and this is the counties that were involved. The Eastern District was Camden, Glenn, McIntosh, Liberty, Bullock, and Chatham. The Middle District was Columbia, Richmond, Burke, Scriven, Jefferson, Washington, and Montgomery. You remember, a lot of these counties are much bigger than they are now. The Western District was Hancock, Greene, Oglethorpe, Jackson, Franklin, Elbert, Lincoln, and Wilkes. Also, these judges would sometimes have to take over for somebody else. Somebody might not be able to be, where they were assigned. Let's look for the next one, Jim. You can see the map of what they had to cover. It's pretty extensive. This is the map. I've got the guy's first name, Elazar, something early. His map from 1818, showing the counties. And you can see that there's quite a distance to travel to get to all those counties. And if you couldn't make it, well, we do know, I'll share this with you. We do know that everything didn't always go as planned. This is from the Tattnall County records from 1815. This being the day appointed by law for the meeting of the Superior Court for the county, and the Honorable Judge of the said Superior Court not attending, I do by power vested in me and acts of legislature and such, make and provided, do hereby declare the court adjourned. Signed, James Ferry. So from time to time, judges wouldn't show up. There was no emails to send, no phone calls to ring. They'd just be all gathered up and the judge wouldn't show. Sometimes they would know in advance that the judge wasn't coming, so a judge of one district would cover for another district. Unique. Talk a little bit about some of these judges. I'm not going to be able to cover them all, but I want to talk about some of the more prominent ones that I came across. We mentioned George Walton earlier. The dates at the top are the dates that they served in Tattnall County. So George Walton was the Superior Court judge here in Tattnall County from 1801 to 1804. If that doesn't just floor you, I taught Georgia history. Like some of our people that were talking earlier, the oral history that I got from my grandfather may have been more illuminating than everything I saw in a Georgia history book, because at least in the early period, because he told me about stuff that was not in there. And this is another one of those things that is just not really covered that well. Here we have George Walton serving as a roving circuit riding chief justice. He was the Council of Safety President back during the Revolutionary period, a delegate to the Second Continental Congress, signer of the Declaration of Independence, a colonel in the militia, was captured at Savannah. He was the governor of Georgia and a U.S. Senator. And this man is conducting court twice a year in Tattnall County, as well as the other counties in his district. George Walton, as you know, was properly called one of the founding fathers of the United States. He was a friend of George Washington. That picture there is from, I believe, when he reviewed the troops at Ebenezer in Effingham County during his visit, I think. I know that's a picture of George Washington. Let's look at some more. Benjamin Scrine was a judge from 1805 to 1807. After retiring, he returned to Washington County. He was named as a commissioner. We heard earlier about the importance of education in Georgia. He was named as a commissioner for the Washington County Academy by the General Assembly in 1819. Note at the bottom, we by leave to return our grateful thanks to his honor, the presiding judge, for his judicious charge given us this term and for his great attention to the business now before him, and for the order and regularity with which he conducts the same, which we esteem worthy of our respect and highest regard. This is Asa Travis, the foreman of the Tattnall County Grand Jury in 1807, entering into the records his heartfelt thanks for the jury for the judge's service. I'll come back to that. Next one. Robert Walker, 1807. I'm gonna segue here just a minute. I'm gonna tell you a little bit about this. I'm not going to try to read all this to you, but if this will bring some relevance here to this. Robert Walker was notable as a Chief Justice. He's a former Attorney General, but he's most noted for his involvement in the first case of judicial review in Georgia. Y'all all heard of Marbury versus Madison, the first case of judicial review at the national level. In Georgia, with this court system that we had the inferior court and then these Chief Justices, there was no Supreme Court, as you will, to review things. But you did have these justices, and they met in the spring and the fall, and the rest of the time, they might get together in, quote, convention to talk to one another about things they'd seen during the year that the law maybe didn't apply too well, or they needed to discuss, and maybe they'd talk about laws that might or might not be constitutional. Well, as it happened, there was something called the Alleviating Acts, and it had been passed, I believe, in 1813 by Governor David Mitchell. Governor David Mitchell had passed or had pushed, got the legislature to push this law, which forgave debts. We were having some hard economic times in Georgia. Crops had failed. You're coming off the War of 1812. A lot of people had some problems with Indians. There was a lot of people who couldn't pay debts, and so the legislature proposed this law called the Alleviating Acts, and it was supposed to alleviate your debt. And the Governor Mitchell signed it, and it was enormously popular with people that had big debts. However, it wasn't so well received in the courts, because now people coming to court with claims would find that the judge would have to say, well, I'm not going to enforce your claim because the Alleviating Act will leave that, so you don't get paid. So the justices started seeing that this was a conflict, and Robert Walker was one of 4 justices, Judge John McPherson Berrien, Young Gresham, and Stephen Harris, who met, and they declared in 1815 that the law was unconstitutional. Well, as it happened, another governor had come in, Governor Peter Early, and he had vetoed the act. And the judge in the grand jury of Tattnall County wrote in the records that they applauded Governor Early for his veto of the act, and the judge at that session was Judge Robert Walker. So the following year, in 1815, those justices got together and declared that act was unconstitutional, much to the chagrin of the people who supported it. And the legislature actually issued a ruling saying that they forbade the justices from meeting in conference ever again. They didn't have the authority to declare things unconstitutional. It was the first case really of judicial review. And Governor Early had also been a Superior Court judge, as had Judge Mitchell. Next one. Another judge was John Hartford Montgomery. He served in Tattnall County from 1821 to 22. Don't know a lot about him. This is his dad's obituary, who was a physician in Augusta. And it just mentions his son, John Hartford Montgomery. T's left out there. But you can see his connection is to his son through that obituary. His wife, he left wife property in Ireland. And Dr. Montgomery's tombstone is the oldest known tombstone in Magnolia Cemetery in Augusta. He died at a young age of 43. Next one. Thomas U.P. Charlton. Thomas Charlton served Tattnall County in the fall of 1822. He served as Chief Justice in those years 1807 to 10 and 21 to 22. He was the mayor of Savannah. He had been the aide-de-camp and protege of General Governor James Jackson. He was elected to the House of Representatives. Jackson suggested to President Thomas Jefferson that Charlton would make an excellent Attorney General for the District of New Orleans. Jefferson didn't agree and didn't give him that post, but he was endorsed for it. He wrote a fantastic complimentary biography of Jackson 3 years after Jackson died. His son, Robert Charlton, became the namesake for Charlton County. Next one. He's so dear to our hearts. Robert Raymond Reed. As we know, the namesake of Reedsville. Robert Raymond Reed, and this guy is a fascinating figure. I'm going to talk about him for just a few minutes. He was born in South Carolina in 1789. He moved to Georgia, studied law, was admitted to the bar. He was a judge of the Middle District from 1816 to 1819, again 1823 to 25. Elected to Congress in 19, served from 19 to 28, so there's some overlap there. He was the mayor of Augusta. He later was the judge of the Eastern District of Florida. He later was the governor of Florida and namesake of Reedsville. He died in 1841 in a yellow fever epidemic in Florida. Judge Reed, and I'll talk more about him in just a few minutes, made such an impact on the people of Tattnall County that, of course, they named the county seat after him. And I'll share a little bit more about him in just a few minutes. Next one. Williams, and I believe the pronunciation is Sly. William Sly, born in Maryland, his family moved to Augusta, educated in Louisville, and admitted to the bar at the young age of 25. Judge of the Middle District, elected to Congress in 29, also a governor of Georgia, oversaw troops in the Indian War, and was fundamental in developing the Western and Atlantic Railroad. He was a strict constructionist and states' rights advocate and the namesake of Sly County. If you notice a trend here, all of these gentlemen are accomplished in other fields by the time they become judges. And many of them are founders of our country. Next one. Other notable early judges, and I'll repeat myself here some, but William White Holt was a lawyer, mayor of Augusta, legislator, judge of the Superior Court, and presidential elector. Other judges included Henry Osborne, a delegate to the Constitutional Convention, John McPherson Berrien, namesake of Berrien County, John Houston, delegate to the Continental Congress and governor of Georgia, William Stevens, mayor of Savannah, David B. Mitchell, the one I mentioned who was involved with the alleviating acts, and the governor of Georgia. So most of these men were either founding fathers of the United States, legitimate founding fathers of the United States, or very, very notable in early Georgia history. To say that they were men of character and accomplishment is an understatement. I'll share a couple of primary sources with you. Next one, Jimmy. This is a typical day for, we know they traveled 1,000 miles annually, mostly on horseback. This is a day in the life of Judge Robert Reed. And this is after he has left Georgia and he's a judge in Florida. And I just want to read some of this. And most of you probably don't have a schedule that's near this demanding, except maybe Ferris. I know Ferris does this. This probably pales in comparison. But this is just, if you just look at this. On 1883, he writes his scheme of life: rise at 5 or 6 a.m., devotions and business to 7, dress, newspapers, and breakfast to 8, newspapers, exercise, calls for business to 3, dinner, rest, light reading to 6.
Wow.
My pleasures and recreations: reading, writing, playing at chess, conversation, wine and water at dinner, toddy after 9 at night, 2 cigars at the same time, and some exercise. The business, official duties to be performed first, private business next. Lose no, and these are some of his mottos, Lose no opportunity of instructing and enlightening my children. Be just and impartial and temperate, kind, frank, and obliging. God help me. Now, like I say, I'm sure many of us have such a demanding schedule, but I want to share this one with you. This is also from his memoirs, and this is from 1832. And he's writing in his journal, and these are some things that we pull from his journal. He typically arose before dawn, spent some time doing daily devotionals, dressed and read newspapers. On May the 27th of this year, he writes and describes his day. I woke at 6 in the morning, read some from the book of Revelations about the witnesses, the candlesticks, the olive trees before the throne, the great beast in the bottomless pit, the sounding of the seventh trumpet. I then prayed and schemed about the transactions of the day. Afterwards, I dressed and wrote an epitome of the aforesaid chapters in Revelation. It was his habit to read and then write his own summary of what he had read, and kept that in his journal. After writing, he had breakfast, then drew his daughter's attention to several interesting tales and paragraphs he saw in the daily newspapers. Then he was off on some errands. He stopped in with 2 or 3 clients, a Methodist preacher named Eliot, whom he noted was a graduate of Athens. Then visited another judge and his wife. After that, he stopped by a store and purchased some gaiters, some sort of leggings, to ward off mosquitoes, which he described as intolerable at night. Then he passed on to the Episcopal Chapel and later stopped at a shoe shop and ordered some boots for his daughters, again to keep off those infernal mosquitoes. After returning home, he distributed candy to his children and noted the thermometer at 80 at 12 o'clock. In his journal for the day, he says he resolved to turn over a new leaf, to be more busy, to be useful, to be better. His day had only just begun, as he typically worked until 8 o'clock every night and did not retire until well past 10 each night. His entries tell us he was a man in pursuit of bettering his physical health, and from his often mentioned bouts with melancholy, he surmised that the way to combat melancholy was to be more busy. So he was constantly looking for things to stay busy with. His usual schedule would call for him to study on Monday law, on Tuesday history, on Wednesday composition, on Thursday law again, on Friday more history, and on Saturday he would devote time to composition. So, as you can see, like many of these early men that were our justices and our judges, they were men of character, men of schedule, men of habit, men of good habits, and they took life seriously. They took their job seriously. They weren't perfect. I'm sure they had, and I've read some. There's some, obviously people had problems. I'm from the school of historical thought that it's good, though, to focus on the positives of people and the accomplishments rather than pick apart everything that they did wrong by today's standards. And I think if we look at them and judging them by the standards of their day, we come away with a better picture of what kind of person they were. So anyway, in the case of Reed, I find that to be very true. Janice, let's go to the next one. The last thing, I don't know how my time is going. I'm good. When the judges met twice a year, they had something called the grand jury was called the grand inquest. And I don't know about y'all, but I learned a lot of my history from my granddaddy. And he told me stories about Beard's Bluff. I'd ask him, I'd say, do we have anybody involved in the Revolution? Yeah, they all were. I said, did we have anybody involved in the Civil War? Yeah, almost every one of them. And I said, really? And he would tell me these tales, and he used to tell me about a big fight on the river, and kind of stuff Mark was talking about, and fights at Beard's Bluff and all this kind of stuff. And I thought, he and I used to sit around and watch Bonanza, a lot, and I thought, well, Granddad's seen one too many episodes of Bonanza, he's just pulling my leg. But turns out all that stuff he was telling us was true. And I'm getting to a point here, but And later about Beard's Bluff, I found a map of a proposed fort that was, to be built there. It was in, Doc Simmons had it in Evans County, he used to build one another place. But one of the things my granddaddy liked to do, well, he liked to drag me off to cemeteries and look at tombstones. That was one of the things you used to do. I gotta tell this one, girl. Y'all, I'm gonna come back to this inquest. Just bookmark that, okay? So, I used to drag my girls off to cemeteries to look at the names on the tombstones and trace the family tree and all that stuff. And I was always telling them about our ancestors. So, ancestors this, ancestors that. So one day I'm watching an old black and white movie about Jim Bowie, and I said, hey girls, look here. This guy here, he went through some of the same stuff your ancestors went through. And they said, okay. I'm trying to get them interested in this old black and white movie. So they watched it for a few minutes, and then they'd had enough. They said, Daddy, you're always talking about our ancestors, our ancestors. Didn't we have any Ann brothers? Back to Granddaddy. All right. So Granddaddy is telling me about all this stuff, and he's trying to drag me off to the cemeteries to look at stuff. One of the other things he liked to do is he liked to get dressed up, put on his suit, and go to town on certain times of year. What was he going to town for? I found out he's going to watch court. He heard they have in Superior Court. He's going to sit up there and watch court. Got his suit on. Now, he liked doing that. He was born in 1897. I'm sure during this period, 1801 to 1833, there was a lot of people who just showed up at court to hear what was going on. There wasn't any TVs, wasn't any emails, wasn't any internet. It was high drama to go down and watch the court. And not only did you go down and watch the court, guess who's conducting court? George Walton, the governor of Georgia. You got some founding fathers in there conducting court. And one of the things they did each time was they addressed the jury. And if nothing else, they'd go to listen to the address to the jury. And these early statesmen had quite an impact on these people with their addresses to the jury. So if you'll just bear with me, I might have to put on my spectacles to see this. And I want to share this one with you. And some of you have probably already seen this or heard it. With the grand jury being impaneled and sworn, the judge then delivered the following charge. Mr. Foreman and gentlemen of the grand inquest, happiness is the end and aim of all human exertions. Whether in savage or civilized life, self-interest delights to administer to its own complacency and to regard its own comforts. As men have acquired new relationships, as the objects of their desire have increased, the necessity to preserve one and to secure the other has given birth to social compacts. To this origin all government may be traced, but unhappily the end of their institution has been perverted, formed for the benefit of the many. The result has dwindled to the aggrandizement of the few. To prove this position, it is only necessary to turn the pages of history and cite you the examples which serve to blemish it. Greece, the asylum of the arts and graces of all that could embellish and give zest to life, became the prey of factions and the victim of despotism. Rome, while eagles proudly soared over a captive world, hailed only for a season the light of liberty. It was upended by the storms that succeeded and was shrouded in the impenetrable darkness of a wayward destiny. Nor was her rival Carthage more fortunate, with a commerce which made her the storehouse of the world, a people enthusiastically attached to their country, and warriors around whose brows the living laurels of victory loved to entwine. Corruption and ambition assailed her glory, and it sank, leaving like the exaltation of the evening a fearful gloom around. Whew. In modern times, the spectacle is not more cheering. Great Britain, to whom we certainly are indebted for some of the best rules and maxims which adorn our laws, notwithstanding the pains of her pacts, the rulerisms of her historians, and the boast of her politicians, wears only the semblance without the realities of freedom. The influence of her crown is exercised to corrupt her parliament, her nobles lord it over a prostrate multitude. with insignia of distinction, boastful of the blood which fills their innervated veins as though its derived source were in a divine fountain, they entertain no sympathies for the honest and industrious poor, whom they believe inferior by nature, and behold through the distorting mirror of their own self-importance an unfathomable depth beneath them. He goes on to list other failed experiments with liberty. He talks about the divine right of kings and bigotry and delusion. But then he turns his attention to our country and he says, gentlemen, and I gather here that he may have been getting so long-winded somebody was losing their attention, because he says, gentlemen, my object is not to amuse, but to instruct. Turn your gaze upon your own country and rejoice in the contrast. While you contemplate the oppressive effects of other governments, you will be more justly able to appreciate the value of that treasure which your ancestry obtained and transmitted to your prosperity sealed with their blood. Here, religion worships the deity, not according to the prescriptions of an established church, but as each conscience shall dictate. Here, tyranny cannot exist. The atmosphere of the Constitution is too pure to administer to its tainted breathings. Here, liberty flourishes like the young oak of the mountains. Here, all men are equal and only the laws are supreme. When we reflect upon these things, when we see the comforts and blessings continually springing around us, all having their root in our excellent form of government, it becomes us to bow in thankfulness to the author of God, that our days have been granted at such a time and our lot cast in such a land. It is our duty to preserve the blessing, not only to bask under its benign influences, but to guard it with sacred care and hand it unimpaired and without blot to the children of coming years. To effect this end, it is only necessary that the people should be virtuous and the laws faithfully administered. A society without law would soon rival pandemonium and confusion and wickedness. With this sublime object in view, I do not hesitate in behalf of your country to demand your best exertions. Assure yourselves that the most effectual mode of preserving the public surety is to detect and punish offenders. Let them feel the fatal effect of disobedience. Let them learn that the state, like the best of mothers, while she protects all, will chastise the thoughtless and the wicked. He goes on to say as a close, gentlemen, the road of your duty is open and clear before you. You are to pursue it straight away, without turn to the right or turn to the left, with a perfect impartiality, without fear, favor, or affections. Signed, Robert Raymond Reed. So, that's what you got from Judge Reed when he addressed the jury. And I can imagine in other counties, in other courts, as those names of the jurors were read aloud in those courtrooms, that judges like him made sure that people took it seriously. And probably wasn't quite as many people seeking to get off of jury duty. But anyway, that is my close. Janice, I think that's my last slide. I thank you for your attention, and it's been a pleasure talking to you. And have any questions? Very good. I covered it all. Thank you all very much.
Great job. I'll bring you